Hello everybody, this is Mr. Seymour, and what we're going to do today is talk about Chapter 4. We're also going to talk about Chapter 13 this week. Both of those deal with liberties and civil rights. So we're going to look at civil liberties on this lecture, and then Chapter 13 will cover civil rights. These will be the last two chapters in this unit before we get to the test at the end of the week. So if you have any questions, make sure you email me, but also this week you're going to have another set of discussion forum questions, and we're going to put up another set of reading questions this week, just to let you know. All right, guys, so we'll get started with this particular lecture. So Chapter 4, Civil Liberties, deals with your individual liberties, your individual rights as guaranteed in the Bill of Rights. And the thing that we need to understand is that your rights and liberties often conflict with other people's rights and liberties. And when that happens, we have to understand the conflict that arises. And then there has to be a set of compromises that are reached in order to placate both sides. So let's look first at the case of the Westboro Baptist Church and the right to free speech. For those of you who don't know the Westboro Baptist Church, these are the people that are from a very small group of people that They go to funerals of service members, and they protest because they believe that they need to get attention regarding their anti-gay rights platform, and they are very vocal. So let's watch this little video.
He's a man both in mourning and on a mission.
This is my fight. It's a private fight.
Albert Snyder lost his son, Lance Corporal Matthew Snyder, in Iraq back in 2006. However, it wasn't until his son's funeral when things went from bad to worse. It was there that members of Westboro Baptist Church came to protest, carrying their telltale signs, cheering his death and all of his fallen comrades.
What kind of country are we if we can't even bury our dead? What's it say about our society?
However, Fred Phelps and the other members of the church insist their message is something the country needs to hear, and add they had the constitutional right to tell it.
You can't say under our Constitution, we don't like his preaching, shut him up.
Snyder bristles at the free speech argument and is now suing the church in a case that will be heard at the Supreme Court next term.
This is more than freedom of speech. This is like yelling fire in a crowded theater. Somebody's going to get hurt.
So far, lower courts have split on the case. The most recent verdict, however, not only ruled against him, but also ordered him to pay Westboro's court costs of more than $16,000. Groups like the American Legion, as well as Fox News commentator Bill O'Reilly, are promising to shoulder that burden. Plus, he's been getting unsolicited donations from random people. Phelps and his daughters, on the other hand, say they've been threatened and attacked, but they insist their message is one the country needs to hear.
Dawned on us in full flower that this nation's destruction is imminent, that there's no turning back this coming awful event.
They say the United States is doomed because it tolerates homosexuality, and the only way to save the country is for Congress to make it a capital crime.
We have a fervent desire to obey God. It's impressed upon my heart every day. He didn't have to pick me.
Snyder contends the church didn't have to pick his son's funeral to protest at either. But church members say they go because that's where they can get the biggest media attention. Snyder calls that despicable.
Speech, that's an insult. That's an insult to my son. It's an insult to me. It's an insult to every military man and woman fighting overseas right now. It's an insult to all the dead.
Legal experts, though, warn the Supreme Court may add injury to that insult. They say it appears the protesters have the law on their side, and warn ruling against them could undermine the First Amendment. Matt Friedman, The Associated Press.
So the question
He's a man.
becomes, do we have the right, the absolute right to express our thoughts above the rights of others? And we in the United States tend to put our civil liberties, particularly First Amendment rights, at the top of our list. Are we willing to give up some of our comfort or freedom to be able to allow for others to have the protection of civil liberties? It's a very difficult question. So let's define what civil liberties are. First of all, civil liberties are basic political freedoms that protect the citizen from governmental abuse and power. This is our firewall between the people and the government. We're going to talk about both civil liberties and civil rights this week, so let's distinguish between the two of them. Civil liberties deal with your basic freedoms and liberties. Civil rights deal with the protection from discrimination. Civil liberties are rooted in the Bill of Rights and the Due Process Protection Clause of the 14th Amendment. Civil rights are rooted in the laws and the Equal Protection Clause also of the 14th Amendment. The civil liberties are primarily there to restrict what the government can do to you. Congress shall make no law abridging the freedom of speech, for instance. Civil rights are there to protect you from discrimination both by the government and by individuals. The distinction between these two can be a little bit confusing because, hey, it's the Bill of Rights. But your civil rights deal with groups and classified groups. Civil liberties are the individual. In general, civil liberties are those things that the government cannot do to its citizens. Civil rights refer to protection from discrimination by the government and by other individuals. So a fundamental problem of civil liberties is how do you balance the competing interests like security, military strategy, and liberty? There is no clear answer as to how to balance civil liberties and national security. When should a government act and when should it use restraint to protect our civil liberties? There is no clear answer, but the courts say we need to err on the side of caution. So this gentleman is a member of a group of churches in Kentucky. They're also in parts of Tennessee and Virginia that deal with the handling of snakes. And do they have an absolute right to practice their religion if that puts others or themselves in danger? Where does the government's responsibility come in? So there are some easy calls and there are some harder calls. The easy calls are, for instance, to balance the interests of freedom of religion and public health. The government uses forbids the use of dangerous snakes in certain fundamentalist church services. So the classic example is you can't yell fire in a crowded theater. That was Oliver Wendell Holmes's example. Why? Because you're putting others at risk and you're threatening their safety. The harder calls are drawing the line between religion and education, for instance. Is student-initiated prayer permitted in a public school? If the students want to bend down on one knee in a public school and pray, can they do that? Freedom to practice religion is one side. Freedom, the Establishment Clause that prohibits the government from sponsoring those religious beliefs is the other side. This is what we call the freedom to practice, or the freedom from religion and the freedom of religion. And there's a conflict there, and we have both freedoms. Can the government help parents pay for tuition in a religious school if it's part of a school choice program? Does a Jehovah's Witness have to salute the flag in the morning if they believe that their religion forbids that? All of those are questions that come under this balancing of interests. So here's another challenge. When is the government engaging in unconstitutionally excessive entanglement with religion? So we have our example of Wisconsin versus Yoder, which was the right of the Amish to remove their children from public education after the 8th grade because they believed that the children did not need worldly knowledge. Yet, on the other side, there's the interest of educating those children and the requirement that those children have to go to school. So there are many issues also related to automobiles. Unreasonable search and seizure. What justifies a highway stop? What constitutes probable cause for a search? There's the recent case, Florida versus Cardenas, which limited the ability of the police to use a drug dog at a private residence because there was a presumption of privacy. Just to kind of let you know what that case was about, there was a house that the police knew was basically a drug stash house. They were called in an anonymous tip and told that it was a stash house. When they got there, they could see that the air conditioner was running, that the house was totally sealed, that the electric use for the house was incredibly high. They could smell the faint smell of marijuana reeking from the house. So they call in a drug dog. The drug dog knew right away that this house had drugs in it. So they bring the drug dog onto the public sidewalk. Then they walk him down the private sidewalk onto the porch where the drug dog then alerts, and then they get a warrant to go into the house, a no-knock warrant. And the Cardenas family, who owned the house, did indeed have a grow operation going on in the house. So they took it to court, and they were able to get the case kicked out of court because at the Supreme Court level, the Supreme Court said there's a presumption of privacy behind what you do in your home, and that the drug dog was somehow interfering with the people's right to what was behind their doors. I don't know that I necessarily agree with this call, but I understand that they erred on the side of caution. So the origins and evolution of our civil liberties. Pre-Civil War, the Bill of Rights was at the federal level. It wasn't until starting with the 14th Amendment that we start to see the Bill of Rights applied to the states. Our Civil War amendments of the 13th Amendment, 14th Amendment, and 15th Amendment, which were there as a reaction to slavery and discrimination, also said that everybody is entitled to due process. We have another case called Gitlow versus New York that deals with the same thing. So we start to see selective incorporation where the Bill of Rights is applied piece by piece to the states. The Bill of Rights would include the first 10 amendments to the Constitution, and it was there to satisfy the requirements of anti-federalists. Before the Civil War, the Bill of Rights would apply only to the national government. It did not protect citizens in the 18th century to the degree that it does now. Barron versus Baltimore is a classic example of that. This is important because in the first 80 to 100 years of our history, the states had a lot of power, a lot more than the federal government did. But after the Civil War, with Reconstruction, that changes. So our Civil War amendments are the 13th, 14th, and 15th Amendments to the Constitution. They abolish slavery, that's the 13th Amendment. They grant civil liberties and voting rights to freed slaves. Civil liberties is the 14th Amendment, Equal Protection Clause, 14th Amendment. 15th Amendment is our voting rights. And these are particularly important as they allow for the civil liberties to be applied at the state level. The Due Process Clause is part of the 14th Amendment. It forbids states from denying life, liberty, or property to anyone without the due process of law. Now, there is a nearly identical clause in the 5th Amendment that applies only to the national government. So the 14th Amendment takes it and applies it to the states. Gitlow versus New York is the first case that finds that the 14th Amendment incorporated certain parts of the Bill of Rights at the state level, and that the states are not free to violate the Bill of Rights at the federal level. So we start with a process that the Supreme Court used called selective incorporation. Selective incorporation is the process where the civil liberties, your civil liberties and my civil liberties that are granted in the Bill of Rights are applied to the states case by case. These rights are protected by selective incorporation and sometimes referred to as the honor roll of superior rights. So we go on and we have a classic case called Schenck versus the United States, which institutes the clear and present danger test. It has to do with free speech. The clear and present danger test says that if what you're saying or doing is a clear and present danger to the public, then it is not allowed, and that means that we restrict certain types of speech as dangerous. You can't yell fire in a crowded theater. The second one is the direct indictment test or incitement test, which protects speech under the First Amendment unless it's directed at inciting imminent lawless action and it's likely to incite or produce action. So we will look at both of those here in just a second. So Schenck versus United States, the clear and present danger test. This is the infamous you can't yell fire in a crowded theater because it poses a clear and present danger to the public. Then in your Brandenburg versus Ohio, that's direct incitement. It protects speech under the First Amendment unless it is directed at inciting imminent lawless action and is likely to incite or produce such action. So let me give you an example. Back in the 1960s and early 1970s, people would protest on campuses across the country, and they were protesting against an ROTC building. So the law would say that it's okay to protest against ROTC programs. It's okay to protest against the National Guard. It's okay to have a sit-in. It's okay to have pickets. It is not okay for someone to say, let's go burn down the ROTC building. And that's exactly what happened. So in that case, that would be direct incitement to riot, direct incitement to do physical damage, okay? Now, the Bong Hits for Jesus case. Students are only sometimes protected by the level of protection that is afforded to adults, which is the direct incitement test. In a case called Frederick versus Morse, you had a student who cut school to attend a march of the Olympic torch through his hometown. He was punished by his school when he raised a banner that said Bong Hits for Jesus. The student wasn't trying to make a point. The banner was a joke, he said. He tried to argue that his speech was partially protected by the ruling of something called Tinker versus Des Moines, which was a case about a brother and a sister that wore black armbands to protest the Vietnam War. So that ruling said that students did have the right to wear a black armband to protest the war, and this is the one that said that children do not leave their rights behind at the schoolhouse door. The court found in that case for the school district, in the Frederick case, and they ruled that his speech was not protected. The takeaway lesson here is freedom of speech does not apply to students talking about drugs in school or alcohol. Can we ban certain things in order to maintain order and some decorum within a school? Yes. And the Supreme Court has said that they will err on the side of caution with regard to giving the power to school administrators to oversee the school. Symbolic speech is the use of nonverbal expression, such as the use of signs and symbols. It benefits from many of the same constitutional protections as verbal speech. The best example was 1989 when, in Texas versus Johnson, the court ruled that a Texas law that outlawed flag burning was unconstitutional. They said it was symbolic speech. Symbolic speech is not protected when it violates other parts of the Constitution, like burning a draft card is not constitutionally protected. Hate speech, expression that is offensive or abusive, particularly in terms of race, gender, or sexual orientation. Currently protected by the First Amendment, so that means that as long as you don't incite, you can have hateful speech or what are called fighting words. So other cases involving hate speech. RAV versus St. Paul. The Supreme Court throws out a law where a teenager was convicted for burning a cross on the lawn of an African-American family. The court said that the teen could be punished for arson, for terrorism, for trespassing, or other legal violations, but the law was, as written, was impermissible. This was called viewpoint discrimination. You can't have that it would be discriminating against them for their viewpoint. In the case of Virginia versus Black in 2003, the court said by a narrowly tailored ban on cross burning, under this contextual view, burning a cross at a Klan rally would be permitted political speech, but burning one on a family's lawn would not. So we went a little bit deeper on 2003 and said that, yes, that would be a hate crime. Snyder versus Phelps is the Westboro Baptist Church, which said that the Westboro Baptist Church is allowed to protest at funerals even if speech is outrageous. So Phelps won that case, and the one that you saw the video about, and so that is considered protected speech. Now, prior restraint. Prior restraint is putting a limit on the freedom of the press that allows the government to prohibit the media from publishing a material. The Pentagon Papers, 1971. The Supreme Court has mostly discarded the governor's prerogative of prior restraint. A prior restraint would mean telling the New York Times, for instance, we know you have the Pentagon Papers. If you publish the Pentagon Papers in your newspaper, then you will be punished for releasing classified information. Well, they can't punish the newspaper or the reporter until after the information is published. Then they could. In the words of Justice Hugo Black, only a free and unrestrained press can effectively expose deception in government. So gag orders are aspects of prior restraint that allows the government to prohibit the media from publishing anything related to an ongoing trial, and they do exist and are legal. All right, less protected speech. Fighting words are forms of expression that by their very utterance can incite violence. These can be regulated by the government but are often difficult to define. Slander and libel, that's spoken and written false statements that damage a person's reputation. Both of these can be regulated by the government, but they are often difficult to distinguish from what are called permissible speech. It is generally almost impossible to get a conviction for slander and libel if the victim is a public official. The example is New York Times versus Sullivan. For public figures, the standard is that the accuser must demonstrate malice or knowledge of falsehood or reckless disregard for the truth. All of this can be mitigated by just saying, hey, it was hot news and we verified as much as we could at the time. So it allows for journalists to work under a time pressure and say that they were trying to get it out, and then they apologize or run a retraction later. The Establishment Clause. When we get to freedom of religion, remember there's freedom of and freedom from. And with regard to the Establishment Clause, that is freedom from. And with regard to the Free Exercise Clause, that is freedom of religion. And we tend to forget that there's this thing called the Free Exercise Clause. So the Establishment Clause is the part of the First Amendment that says that Congress shall make no law respecting the establishment of a religion, which has been interpreted to mean that Congress cannot sponsor or endorse any religion. Now, the Free Exercise Clause is the part of the First Amendment that says that Congress cannot prohibit or interfere with the practice of religion. So that is freedom of religion. Many controversies surround the church and state issues are involving what children are taught. Compulsory prayer was forbidden in 1962-1963, which is in Engel versus Vitale and Abington Shemp. In that case, the children would stand up and say a prayer that was like, bless our teachers, bless our parents, bless our families, bless our country, and so forth, bless the president. And they all said the same prayer and they recited it. Now, the Lemon test comes from the case of Lemon versus Kurtzman, and that's the test that we use today. Supreme Court uses this test to determine whether a practice violates First Amendment Establishment Clause. This test claims that any government aid must have a secular purpose and it does not advance or inhibit religion, and if it does not foster an excessive entanglement, it's legal. The court is moving away from it towards an increasingly accommodationalist perspective, as in the case of Zellman versus Simmons and Harris. The court ruled that tuition vouchers, for instance, that were given to parents did not constitute impermissible state support of religion because the vouchers would go out regardless of the religious beliefs. Court's majority argued that the program was constitutional, and since the aid went to parents and not to the schools. So here's another one. Can a cross be displayed on federal land? The Supreme Court ruled that religious displays on government property need to be part of larger secular displays. This cross on federal land in the Mojave Desert was covered up after it became controversial. Here's another one. Tom Green. Lawyers for Tom Green argued that laws against bigamy and polygamy infringed on his religious freedom. Green belonged to a fundamental sect of Mormonism that preaches plural marriage, more than one wife. When this photo was taken in 2000, he had 5 wives and 29 kids, and he eventually was convicted on 4 counts of bigamy and later sexual assault, because he violated the law. But the fact that he had more than one wife wasn't necessarily a violation, but he was eventually convicted on bigamy and child sexual assault. So, right to bear arms, right to keep and bear arms. Second Amendment reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, the most recent case of Columbia versus Heller and McDonald versus the City of Chicago both said that the Second Amendment refers to rights of individuals to own a firearm, not just a state, and not just because you're a member of a militia. And this says that the states are federally controlled federally controlled territories like the Washington, D.C. could not forbid the ownership of a handgun because the Second Amendment allows it. So, due process. Due process rights are the rights, the protections that we have when we're accused of a crime. And these are the 4th, the 5th, the 6th, and the 8th Amendments. These include protection from unreasonable search and seizure, the right to a fair trial, the right to consult a lawyer, the freedom from self-incrimination, the ability to know what crime you're accused of, and the right to confront your accuser. Now, we have to balance those due process rights with a post-9/11 environment where the Patriot Act is giving the government more authority to enter into our rights. So where do our due process rights begin and end, and who's entitled to them is a big issue. One thing we need to know about Fourth Amendment, which is your search and seizure, is probable cause. Probable cause is necessary before you can get a search warrant. The restriction is relaxed in schools where, when you consent to search. Exclusionary rule. The exclusionary rule says, or the fruit of the forbidden tree rule, says that illegally obtained evidence can't be used in a trial. This has become weakened over time because, like for instance, the Patriot Act authorizes roving wiretaps where a single warrant allows for the surveillance and investigation of all forms of communication, and something called sneak and peek searches, which are the police go in the home, look for evidence, and don't tell the suspect that they were there. And then the other is no-knock searches, no-knock warrants. So your Miranda rights. When you're accused of a crime, you have Miranda rights. This is a list of civil liberties that are described in your Fifth Amendment that must be read to you. Like double jeopardy, being tried twice for the same crime. You have the right not to incriminate yourself. So this is the one that says you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to your attorney and have him present with you while you are being questioned. If you cannot afford an attorney, one will be appointed to represent you before any questioning, if you wish one, and then you have to sign off. And they have to read you those rights. Suspects can be acquitted on criminal charges but found guilty on civil charges if under a double jeopardy, and suspects can be tried in federal and state court for the same crime. So if it's a drug crime, they might try you in state court. If you get off in state court, they can try you in federal court. Fifth Amendment also includes the concept of something called eminent domain, which, for instance, in Lewis versus the South Carolina Coastal Council, the court ruled that a landowner was entitled to substantial monetary settlement after a zoning commission banned construction on his part of a barrier island, and it dropped the value. Another one called Kello versus New London was a recent case about government's taking powers. The courts ruled in favor of the city and the rights of the county to take property through eminent domain in order to promote economic development. Now, does that mean that they should be able to take your house in order to build an amusement park or a new mall or a business park? In some cases, yes, especially if it's designed to alleviate urban blight. So your right to an attorney, regardless of what you're accused of, comes through the Sixth Amendment down, and it was really put into place in Gideon versus Wainwright, which is an interesting case because Clarence Gideon was an elderly man who was illiterate. He knew enough, though, that he went to a library in the prison that he was put to because he was forced to defend himself in a court. And when he went to the library, he wrote what's called a writ of habeas corpus and a writ of ceteris paribus, or certiorari paribus. And basically, it's it's an order to be brought in front of the court. So they said that you have the right to have an attorney regardless of what you're accused of. If it's a criminal offense, and you can go to jail. You have the right to a speedy trial, and you have the right to a trial by jury. In 1972, you had the death penalty banned in the case of Furman versus Georgia, which was reversed in 1976 in a case called Gregg versus Georgia, where the states moved to a two-step process before applying the death penalty. One was a guilt or innocence phase, and then the other was a punishment phase. Proportionality means that the court has struck down punishments that were disproportionately cruel for the crime, which is a violation of the Eighth Amendment. Unusual punishment, cruel and unusual punishment. So your right to privacy. Do you have a right to privacy? Privacy rights are the liberties that are protected by several amendments in the Bill of Rights that shield certain personal aspects of our lives. But then again, in a year of the cloud, is anything private? There is nothing in the Constitution explicitly talking about privacy, nor is the word privacy found in the Constitution. The right to privacy isn't mentioned until a 1965 case called Griswold versus Connecticut, and it is interpreted as being in the Ninth Amendment to the Constitution. The case of Terry Schiavo would draw recent national attention in 2005 when the parents and the husband of a woman who had been on life support for 15 years could not agree about whether she should be taken off the machines. Ultimately, she was taken off and allowed to die. The other issue that followed Oregon's passage of assisted suicide laws, called the Death with Dignity Act. The law was passed by popular vote of Oregons in 2004. The Attorney General sought to have the license of doctors who prescribed lethal drugs to patients who requested them to have them revoked. The Supreme Court upheld Oregon's laws. Also, gay rights are considered under civil rights, but Lawrence v. Texas found that laws restricting sexual conduct among gays were unconstitutional, thereby expanding the right to privacy. So in Texas, even up to 2003, there were laws that forbid sodomy. And so just practicing same-sex was illegal. A consensual same-sex act was illegal. So let's see where we are. The First Amendment is the roots of our tree. Freedom of religion, establishment, exercise, freedom from, freedom of. Freedom of expression is guaranteed through freedom of the press, freedom of speech, both symbolic and print. Freedom of petition of government, and freedom of assembly. And that is the end of this lecture. and then we'll go on to lecture 4.